Let's hear what the argument in place for Trump and the Supreme Court on this tariff. I'm going to go straight into it, so come in. What is it saying? Okay, let's go in.
On economic security, and that fixing them will make America a strong, financially viable, and respected country again. Due to IEEPA tariffs, President Trump has negotiated agreements worth trillions of dollars with major trading partners, including most recently China. Unwinding those agreements, he warns, would expose us to ruthless trade retaliation by far more aggressive countries and drive America from strength to failure with ruinous economic and national security consequences. In Dames and Moore against Regan, this court held that IEEPA's sweeping and unqualified language grants the president's actions the strongest presumption of validity and the widest latitude of judicial interpretation. Yet plaintiffs argue that tariffs, IEEPA's least blunt and most nimble tool, are virtually the only tool that Congress did not grant the president to deal with foreign emergencies. That is wrong. The phrase regulated importation plainly embraces tariffs, which are among the most traditional and direct methods of regulating importation. And plaintiffs concede that IEEPA authorizes quotas and other tariff equivalents. The major questions doctrine does not apply here. IEEPA confers major powers to address major problems on the president, who is perhaps the most major actor in the realm of foreign affairs. And the non-delegation doctrine casts no doubt on IEEPA because Congress may assign the president broad authority regarding the conduct of foreign affairs where he enjoys his own inherent Article II powers. I welcome the court's questions.
Would you spend a few minutes on why exactly the major question doctrine doesn't apply to the president in this case?
Yes, Justice Thomas, and I may make 2 or 3 points on that front. First of all, though the major questions doctrine may apply to the president in other contexts, specifically in the foreign affairs context where he has his own inherent Article II authority, it's a particularly poor fit to apply the major questions doctrine, and that's for at least 2 reasons. First of all, just as a matter of kind of common sense interpretation, one would expect Congress to confer major powers on the president to address major, sort of foreign, international crises, so to speak, in foreign arising emergencies, that's just sort of a natural common sense thing you expect Congress to do. And in fact, Justice Jackson in his Youngstown opinion addressed this very situation in pages 652 and 653 when he says, this is the system within this is the procedure within our constitutional system that we have developed to strike the balance. What Dames and Moore described as the never-ending tension between the need for the executive to have a robust power to address emergencies and to subject it to checks and balances. What our constitutional system has devised to address that particular problem, that never-ending tension, is the system where Congress confers broad and necessary powers in advance and subjects them to ongoing political oversight, which is exactly what you see in IEEPA. So that's one reason. One reason, just as a matter of common sense interpretation, you would expect Congress to grant major powers to the president, who has his own broad range of major authority, inherent Article II authority in this context. And that is buttressed by the second point,
which is... General, there, and I know that you have a second question, and I want to let you get to that. But just on that first reason, it seemed to depend a lot on the president's inherent
He's relying on interpretation.
And I'm wondering what exactly, which powers you're speaking of there. Because tariffs, one would naturally think, is are the power to impose taxes, the power to regulate foreign commerce. These are not things that are thought of as Article II powers. They are quintessential Article I powers. So what kind of Article II powers are you relying on when you gave the answer about major questions to Justice Thomas?
I would refer to what the court said, for example, in Egan, Department of Navy against Egan. That's a generally accepted view that the president has broad authority in the foreign affairs realm. Now, there's debates about exactly how far it goes and how to draw the boundary between the president and Congress, but Egan, Garamendi, other cases, Curtis Wright, the court has recognized the president has broad inherent authority to address foreign situations, foreign affairs, foreign policy, including foreign arising emergencies. Now, we don't contend that he has at least in peacetime inherent tariffing authority. What we have here is two layers. There's the layer, the bedrock of the president's inherent Article 2 powers, and layered on top of that is a sweeping delegation of authority from Congress. When you put those two things together, Congress is saying you have inherent powers to address international emergencies, and we're conferring on you the tools, including Article 1 tools, like, for example, the power to regulate foreign commerce. And I want to make a very important distinction here. We don't contend that what's being exercised here is the power to tax. It's the power to regulate foreign commerce. These are regulatory tariffs. They are not revenue-raising tariffs. The fact that they'd raise revenue is only incidental. The tariffs would be most effective, so to speak, if no person ever paid them, if they achieved their goals. If that
Counsel, you've already mentioned Dames and Moore three times, which surprises me a little because the court in Dames and Moore went out of its way to say that it was issuing a very narrow decision that pretty much expected to apply only in this case. Just a few quotes. It said, decisions in this area have been rare, episodic, and afford little precedential value for subsequent cases. Again, we lay down no general guidelines covering other situations not involved here and confine the opinion only to the very questions necessary to decision of this case. And it ended the opinion. It said, finally, we re-emphasize the narrowness of our decision. Now, this at issue in Dames and Moore was a different provision of IEPA, not at issue here. It certainly did not concern tariffs. So I don't quite understand how you can get as much out of Dames and Moore as you're trying to get.
Maybe I could put it this way. You don't dispute that Dames and Moore is, as you state, a narrow opinion. However, it addressed certain principles that we think are equally applicable here. For example, the interpretive principle. Dames and Moore held, and again, it was the power to nullify and void, not the power to regulate, but it's in the very same sentence, in the very same statute, and the court quoted the First Circuit opinion and said, look, this is sweeping and unqualified language, which it didn't disagree with. And then it said, this particular provision where Congress has given these broad verbs, I mean, regulate is a capacious verb, admittedly, so are nullify, so are void, so are frankly all the other verbs there in the language in IEPA. The way the court thought about it is we are looking at this through the lens of Justice Jackson's opinion in Youngstown, and the court held specifically that these verbs place the president in Youngstown Zone 1. The court held that he is subject to the widest latitude of judicial interpretation, that he received the strongest presumption of validity.
I just don't understand this argument. It's not an article. It's a congressional power, not a presidential power to tax. And you want to say tariffs are not taxes, but that's exactly what they are. They're generating money from American citizens, revenue. And you say it's incidental to the regulatory purpose. But I don't see how a quota is equivalent to revenue raising. A quota sets a limit to what you can import in, but it doesn't generate revenue. I don't understand this argument, that it's equivalent, or that foreign powers or even an emergency can do away with the major questions doctrine. Didn't we in the Biden case recently say an emergency can't make clear what's ambiguous?
As to that point, I believe the court has never applied the major questions doctrine into foreign policy context.
But we
That's
have.
emergency context, not foreign policy
Counsel,
context.
we have never applied it to foreign affairs, but this is a tariff. This is a tax.
It is a, if I may, it's a foreign-facing regulation of foreign commerce. That's a regulatory tariff distinct from a tax.
So Biden could have declared a national emergency and global warming and then gotten his student forgiveness to not be a major questions doctrine?
I don't think he could have gotten student loan forgiveness.
Why?
But
It's
perhaps he could
global.
have.
It's foreign facing. We need all of these things to face to tax fossil fuel or to do something else. That's all Biden would have had to do with any of his programs.
Let me put it this way, if I may.
Is just declare some foreign-facing purpose?
If I may, look, maybe I can articulate it this way. The power to impose tariffs is a core application of the power to regulate foreign commerce, which is what the phrase regulate importation in IEPA naturally evokes. Not the power to tax.
Could you tell me why it is that when Congress intended to permit a president to regulate by imposing tariffs, it's always used tariff and regulate? I have about 16 laws in the past that when Congress intended regulate to mean taxing, that it used taxes simultaneously. But it didn't here.
Respectfully, this court came to the opposite conclusion, if I may, in Algonquin, where the phrase was not in.
Well, but that was, we did something in Algonquin, it was in the duties section. It's unlike here. It was paired with questions about decreasing tariffs and increasing tariffs. So it's a very different statute than the one at issue here.
But the governing language, admittedly, the references to duties in section 232A, 232C does not refer to them, and the court didn't refer to 232A at all, or the phrases duties or tariffs as analysis. What it held was the phrase adjust imports, which includes a verb that's narrower.
But it was in the context,
actually encompasses.
it was in context of activities that had to do with raising and lowering duties. Here, the verbs that accompany regulate have nothing to do with raising revenues in the form of taxes.
And counsel, Algonquin wasn't a textualist opinion. Do you agree with that? In other words, the analysis that the court was using there was really key to the legislative history of that statute, and it wasn't as though we were doing an interpretation of the word adjust.
I disagree with that. I think you read the opinion, first it talks about plain meaning, then it talks about statutory context, and then it goes on to legislative history, so it was all three of those. And the conclusion it came to, it directly addressed and rejected the argument that the D.C. Circuit had accepted in that case, which is that when Congress wants to delegate the authority to tariff, it uses a consistently explicit and well-defined approach, which is to use these magic words, tariff, tax, impost, and so forth.
All right, let me-
The court said, no, Congress is not bound to use that particular formulation once it confers this power.
Let me ask you about the premise of your argument, which you sort of started at the beginning saying that one would expect for Congress to give the president a broad leeway in this kind of foreign affairs context. And I guess I'm wondering whether you also don't have to contend with the actual purpose of IEPA in making this argument, because as I understand it, that the IEPA was designed and intended to limit presidential authority, that Congress was concerned about how presidents had been using the authority under the predecessor's statute, TWIA, and it's pretty clear that Congress was trying to constrain the emergency powers of the president in IEPA. So it seems a little inconsistent to say that we have to interpret a statute that was designed to constrain presidential authority, consistent with an understanding that Congress wanted the president to have essentially unlimited authority.
I disagree with that because what Congress actually did as...
What part do you disagree with? I'm sorry.
Well, I disagree with the notion that they were trying to constrain the breadth of the actions the president may take when it comes to this particularly narrow domain, which is, various regulations of transactions.
But how can you disagree with that? I mean, the history is what it is.
Because they made a series of changes to IEPA
Yes.
that relate to the triggering conditions, so to speak, and the procedures that apply, but they did not change the language in IEPA.
Right, but what was the intent of Congress in changing the language? Wasn't it to constrain presidential authority in this area?
To constrain it in the triggering conditions and the procedures that apply in this.
So those are the triggering
context.
the triggering conditions and procedures that apply are a means to constrain. That is how they went around about constraining. But my point is that Congress enacted this legislation with the intent of preventing the president from having unlimited powers in this area, and you're asking us to now interpret that statute consistent with an understanding that Congress wanted to allow the president to do pretty much whatever he wanted in this area.
Congress took the language from TWIA and enacted the very same language, and most importantly here, the very same phrase, regulate importation, in IEPA. And therefore, the natural inference is Congress did not intend to change the scope of authority, the powers, the tools the president can exercise.
Did any
to address
president
foreign
under
emergencies.
TWIA use that language to impose tariffs?
Well, yes, President Nixon's 1971
Not a tariff.
visibly.
That wasn't a tariff. It was a licensing agreement during wartime. It was a specific thing. Tariff I'm talking about.
I'm referring to President Nixon's 1971
Oh,
tariff.
I'm sorry,
Yes.
excuse me, yes, I thought you meant Lincoln.
Not only that, but then it was upheld by the Court of Appeals with exclusive jurisdiction under this very phrase.
Can I back you up
regulating
just a
importation.
second? I'm sorry, you're talking so quickly.
Sorry.
President Nixon did not rely on TWIA initially to impose the tariffs.
I
Is
don't
that
get-
correct? I understood that was just a litigating position that he took once it was challenged. That was not his initial.
I wouldn't put it that way because he has a broad invocation, I'm invoking all range of statutes, something like that, in Proclamation 4074, and I think the understanding is he didn't want to kind of spook our allies by invoking the Trading with the Enemies Act by specifically invoking it, but in litigation was defended on that ground. So the Department of Justice defended it as an exercise of TWIA and did so successfully.
What's the significance of the Nixon example and precedent here? Because I think figuring that out is real important to deciding this case correctly. So,
Well, there's one obvious, very powerful takeaway from it, which is that this very two-word phrase, regulate importation, that we say it carries with it the authority to tariff, impose regulatory tariffs at the border, forward-facing tariffs at the border, and we say that's a core application of the phrase regulate importation, had been interpreted 2 years before Congress reenacted that language in IEPA, had been interpreted to carry with it the authority to impose tariffs. So this court said in Algonquin, for example, with respect to President Nixon's
just back on the Nixon, what was the scope of the Nixon tariffs?
10%, he imposed a 10% tariff kind of across the board to all our major trading partners to address a balance of payments deficit, where he was trying to bring all the major industrial nations to the negotiating table, which he successfully did, but for the imposition of the tariffs, and they negotiated the Smithsonian Agreement in about 5 months, after which he lifted the tariff. So the tariff there was used as here, in part as leverage to get our trading partners to the negotiating table, and it was subsequently upheld by the Federal Circuit, the CCPA, its Federal Circuit's predecessor, that had exclusive jurisdiction over that question, to include the power to tariff. And then 2 years later, Congress took that same phrase and reenacted it in IEPA after carefully studying the problem of presidential emergency powers and being deeply concerned about, excessive or abusive exercise of that power. So that whole sort of process gives sort of strong sort of confirmation this phrase, regulated importation, carries with it the power to tariff. Now, of course, that's not our leading argument. Our lead argument on interpretation is there's a pedigree, historical pedigree of regulating imports specifically, where the power to tariff is just the sort of a core application of that, a quintessential exercise of that power. That goes back to Gibbons against Ogden and Justice Story's treatise and runs all the way through cases like McGoldrick and Board of Trustees.
General Sauer, can I just ask you a question? Can you point to any other place in the code or any other time in history where that phrase, together, regulate importation, has been used to confer tariff-imposing authority?
Well, as to regulate importation, that was held in TWIA. So obviously, and that's...
Okay, so an intermediate appellate court held it in TWIA, but you just told Justice Kavanaugh that wasn't your lead argument, that your lead argument was this long history of the phrase regulate importation being understood to include tariff authority. So my question is, has there ever been another instance in which a statute has used that language to confer the power?
Well,
putting aside Yoshida.
I mean, obviously, other statutory examples of just imports. The cases we rely on are cases where, for example, in Gibbons, it's Ogden and Justice Story's
But that
treatise
just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
I think our argument goes a bit further than that as an interpretive matter, because if you look at that history, the history of
Would
delegation...
you just answer the Justice's question?
Can you identify any statute that used that phrase to confer tariff?
Yeah, the only two statutes I can identify now are TWIA, as interpreted in Yoshida, and then closely related, not regulate importation, but adjust imports in section 232.
Well, I think adjust imports is differently. So the answer is the contested application in TWIA and then now in IEPA.
And then, of course, I mean, there's a sort of direct line there.
Yeah, I understand that, but okay.
But then more fundamentally, we rely on the historical sources to show there's this long historical pedigree of broad delegations of the foreign commerce power, not the power to tax that we're not asserting here, delegations of the foreign commerce power to the president, going back to Gibbons against Ogden, all the way through McGoldrick and Board of Trustees, where this court and founding era sources say the power to, in other words, the power to tariff is kind of this natural, as everyone knows, that includes.
Just ask you one other question about the plain text, General Sauer. So you've referred to the other verbs in IEPA as capacious. Would you really describe them as capacious? Because to me, things like nullify and void have definite meanings. I agree with you that regulate is a broader term, but those words I think are powerful. They pack a punch, but I wouldn't describe them as capacious in the sense that they have a wide range of meanings. So can you describe what you mean by capacious?
Let me put it this way. You look at all 9 verbs together, and you're looking at a spectrum of powers from the most sort of negative, nullify, block, prohibit, void, to the most affirmative, direct, compel, and then also powers in between that are more intermediate, regulate, investigate, and so forth. So the natural common sense inference from that grammatical structure is the intention of Congress to sort of cover the waterfront.
Well,
to grant the
possible,
power
possible, except Congress did take out a whole bunch of verbs. It took out confiscate, vest, hold, use, administer, liquidate, sell, which were in the prior statute. And crucially, what it doesn't have here is anything that refers to raising revenue. So it has a lot of verbs, it has a lot of actions that can be taken under this statute. It just doesn't have the one you want.
Well, I would say the notion that all these other verbs are sort of not revenue raising, like block and prohibit, I think that argument is unconvincing for 2 reasons. One, of course, is that we're not saying it confers a revenue raising power, we're saying it confers a regulatory power, and that's a crucial distinction. But also...
Yes, but if I can just stop you there, regulatory power, I mean, yes, it says regulate, but I'll broaden out Justice Barrett's question. Is there any place that you can find in the entire code where regulate, used just as regulate, includes taxing power?
We don't assert that. We say it includes tariffing power when it's combined with importation, and that's just the most natural.
Right, because the natural understanding of regulate, even though in fact we can regulate through taxes, but when the code uses regulate, we don't typically understand it to refer to duties or taxes or tariffs or anything of the kind. And then if you look at the flip side of this, and you look at all the tariff statutes that Congress has passed, I mean, they use language about revenue raising, tariffs and duties and taxes. All the language that does not appear in the statute you rely on.
Start with sort of grammatical structure of the statute, then refer to the other statutes. Regulate importation. You put those 2 words in combination. That's the inference from that is, the founders discussed with this sort of like, as everyone knows attitude. Regulate importation, one of the most natural applications of that is the power to tariff. So when Congress confers the power to regulate imports, it is naturally conferring the power to tariff, which it has delegated to the executive branch, again and again and again going
I'm
back
sorry,
and forth.
counsel, it doesn't say regulate tariffs, it says regulate importations and exportations. You agree that they can't put taxes on exportations?
From the state, yes, we agree with that, yes.
All right, so why should we think that it's natural then to think that regulate importation includes taxing importations?
Because that is
It's
how...
in the conjunctive, importations and exportations. If they can't do it with respect to exportations, why are we permitting them to do it with respect to importations?
Because as this court has recognized, going back to Gibbons against Ogden and going through McGoldrick and Board of Trustees, the phrase, when you're regulating imports, tariffing is a core application of that. So in other words, if you're saying go regulate trading in securities,
So why
that
is
come with a
it
tariffing
that Congress,
connotation.
why is it that Congress has always used regulate and tax together in the code? Are you telling us that with respect to its use of regulate in other statutes, the taxing reference is superfluous? They didn't need to do that?
I'm not sure what other statutes use regulate and tax together, but this statute has a specific historical pedigree going back to its enactment during World War I in 1917, where the phrase regulate importation is evoking an inherent power to tariff that became established in the 19th century in cases like Hamilton against Dillon and so forth. That history is, I think, set forth in Professor Baumsei's amicus brief.
Counsel, some time ago you dismissed the applicability of the major questions doctrine, and I want you to explain that a little bit more. I mean, it seems that it might be directly applicable. You have a claim source, an IEPA, that had never before been used to justify tariffs. No one has argued that it does until this particular case. Congress uses tariffs in other provisions, but not here, and yet, and correct me on this if I'm not right about it, the justification is being used for a power to impose tariffs on any product from any country in any amount for any length of time. That seems like, I'm not suggesting it's not there, but it does seem like that's major authority, and the basis for the claim seems to be a misfit. So why doesn't it apply again?
Well, we agree that it's a major power, but it's in the context of a statute that is explicitly conferring major powers, that the point of the statute is to confer major powers to address major questions, which are emergencies. So it'd be unusual to say, look at the statute and say, we're not going to find a major power here.
Well, but the exercise of the power is to impose tariffs, right? And the statute doesn't use the word tariffs.
But it uses the word regulate importation, and historically a core central application of that, a big piece of that, has always been to tariff. If you had asked the founders, how do you regulate imports, they would say, of course, we tariff. That's what we do. So it'd be very unusual to say, we're giving you power to regulate importation, and say, but you cannot impose regulatory tariffs. That'd be almost a contradiction. And all the historical sources we cite in our brief, relate to that particular historical pedigree. And as I was referring to earlier, there's a specific pedigree of regulated importation here in the specific context of the presidents Polk and Lincoln and President McKinley asserting the authority to impose tariffs in wartime. That was then codified in TWIA and then recodified for peacetime in TWIA in 1933 and then carried over into IEPA. So there's that as well. But more importantly, if you look at the sort of triggering conditions that members of this court have identified for the major questions doctrine, there's a series of them, and we think they really do, all of them don't apply here. For example, the notion that the power is unheralded. You referred to the fact that IEPA has never been asserted to invoke tariffs, but of course, the immediately predecessor statute, the tariffs that President Nixon imposed on that were upheld under this very language. So this, I would say this is, and it was recodified in IEPA 2 years later. So this is kind of the opposite of unheralded power. It's also heralded because there's this long-standing delegation, a tradition of very broad delegations of the foreign commerce power going back to the founding, going back to the
foreign commerce part, but I mean, and I think this is a question for the other side as well. It's two-facing. Yes, of course, tariffs, dealings with foreign powers, but the vehicle is imposition of taxes on Americans, and that has always been the core power of Congress. So to have the president's foreign affairs power trump that basic power for Congress seems to me to kind of at least neutralize between the two powers, the executive power and the legislative power.
Let me say two things in response to that. First, the notion that the taxes are all borne by Americans and are not borne by foreign producers whose goods are imported is empirically, there's no basis for that in the record. It's actually a mix.
Well, who pays the tariffs? If a tariff is imposed on automobiles, who pays them?
Typically there'd be regardless of who the importer of record is, there'd be a contract that would go along the sort of line of transfer that would allocate the tariff, and there'd be different, sometimes the foreign producer would pay them, sometimes the importer would bear the cost. The importer could be an American, could be a foreign company. A lot of times it's a wholly owned American subsidiary of a foreign corporation. So it gets allocated. The empirical estimates range from like 30% to 80% of like how much is borne by Americans.
It's been suggested that the tariffs are responsible for significant reduction in our deficit. I would say that's raising revenue domestically.
There certainly is an incidental and collateral effect of the tariffs, that they do raise revenue, but it's very important that they are regulatory tariffs, not revenue-raising tariffs. And the way you can see this, I think, if you look at this policy is by far the most effective if nobody ever pays the tariffs. And I say two policies, right? So if you look at the trade deficit emergency, if nobody ever pays the tariffs and instead Americans direct their consumption towards American producers and stimulate the rebuilding of our hollowed out manufacturing base, then the policy is by far the most effective. So a tariff, a regulatory tariff that...
Why not do what the statute permits? Bar importation of products altogether. That would be the most effective way to do it.
What the question
You
was...
follow the statute. The statute says the president
Follow the statute.
What it doesn't say is the president can raise revenue.
What it says, he can regulate importation and going back for
Regulated
hundreds of
by
years, the way you regulate
quotas,
tariff.
pausing it, subjecting some countries and not others to importation bans.
The ones
There's
that
a
benefit
lot
him
of
the most.
verbs, but none of them include generating revenue.
No,
As
it
a side
creates
effect
revenue in
or
his
direct-
in his pocket.
Let me address that verb point, if I may, because think about the canonical example, a statute that refers to a list of swords, knives, daggers, dirks, and pikes. There you look at that list of things and you say, aha, those are all weapons, therefore a pike is a spear, not a fish in that particular context. Now look at this list of verbs, block, prohibit, compel, direct, and so forth. You don't look at that naturally as an ordinary reader and say, oh look, they're all not revenue raising. What you say is, they're all very broad, powerful, actions that you can take.
The verbs that are in the statute are actually doing something. I mean, they're in the statute for a reason, and as I understand it, Congress actually explained to us in its Senate report and House report when it enacted the 1941 amendments to TWIA, what it was doing. It said that what we are doing is authorizing the president, in the Senate report, quote, to control or freeze property transactions where a foreign interest is involved. There's similar language about controlling, freezing control in the House report. So I appreciate that generally you can look at these words and you can imagine that they mean certain things, but here we have evidence that Congress was actually trying to do a particular thing with respect to the authority that it was presenting to the president, and that thing was not raising revenue.
I think that the powers that Congress was conferring on the president are best understood through the plain text of the statutes, which includes regulating.
No, I know, but some of us care about the legislative history. And so
Right.
the plain text of the statute has certain verbs in it. It also has regulate commerce, as you say. And when I look at the legislative history, it appears as though Congress was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And in the TWIA context, that makes perfect sense because we're talking about a wartime dynamic. And what is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of this statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this was really to give the president a certain kind of authority to freeze the assets of the enemy.
And let me say two things in response to that. First, as the notion that this is a revenue-raising tactic.
It is for him in his pocket, not for the U.S.
Foreign commerce. The way to control imports traditionally has been to tariff them. They say, well, you can impose quotas. Well, quotas are essentially economically equivalent.
Making
to
them
tariffs.
buy his
So the question is, why would
coins.
you be able to quota under-regulate but not tariff under-regulate when the tariffs are themselves regulatory? And let me turn back to the question the response I was giving.
Could the answer be that in other places where Congress wants that particular form of regulation to be used, they say impose duties. They say you can tax, Mr. President. Here they don't say that.
I'd say two things in response to that. That's the very argument that this court rejected in Algonquin. That the fact that these other specific statutes,
If we disagree with
say
you
this
about,
way, you have to
if we
this
disagree
way.
with you that Algonquin is a similar context, do you have another statute or another circumstance?
And again, not to cite Algonquin again, but obviously
Yes.
we discussed the phrase adjust imports. And they said, the natural way to do that is to tariff them. And it specifically said it makes no sense at all to authorize quotas, which was conceded that statute did authorize, but not tariffs, because those are equivalent.
But it said adjust by any means necessary, which kind of beefs up the adjust. And also, and this is actually, I just don't know the answer to this question, so maybe you can help and maybe the other side can help as well. Algonquin was very careful to always call it a license and a licensing fee, and in the oral argument that came up too, the distinction between a tariff and a licensing fee. And I can understand how in some contexts it would be very difficult. You would press on it and you would say, well, if this license fee is raising revenue, then it actually functions as a tariff. But what is the significance of that? Because in IEPA, it also says, it refers particularly to licenses. It says you can license. And license would be a way of giving permission that's actually the language also used in the Civil War one, and what is it?
Hamilton against
Yeah.
exactly, yes, it does.
It was a license fee, and that's a way to grant permission that you wouldn't otherwise have to trade and import and let it through. So tell me what the distinction is between licenses and fees, and if it matters.
It's hard for me to see one, because what President Lincoln said is, okay, we're going to allow imports from hostile foreign powers, basically rebellious Confederate states, of cotton subject to a license, but you got to pay 4 cents a pound of cotton when you do it. That's the condition. That is so nearly equivalent to a tariff that says you can bring this goods to our country, but you got to pay a ad valorem assessment on it. And of course, they have in their briefs conceded that quotas apply, that licensing may apply. There is the language in the beginning of 1701 that talks about instruments, or other methods, instruments, licenses.
But if that were true, why couldn't you just call this a license? And it's also true that in the cotton example, the court said the exaction itself was not properly a tax, but a bonus required as a condition precedent for engaging in the trade. So it seems like it was a little squirrely about how it was proceeding. And if there really is no distinction, why couldn't you just call it a license here?
Very briefly, the other two cases, the Polk case and then the President McKinley case, talk about duties. So I see an equivalence there, Mr. Chief Justice.
Thank you, counsel. Justice Thomas, anything further?
The other side is going to argue, make an argue on delegation, I believe. Would you anticipate that and give us your understanding of the delegation argument?
Yes, Justice Thomas, I'd say a couple things in response to that. First of all, this court has stated that the non-delegation doctrine does not apply with anything like the same force as it does in the domestic context in the foreign context. And that, again, to cite Dames and Moore again, Dames and Moore cites Youngstown, and Youngstown in footnote 2 of Justice Jackson's opinion, he goes into detail about this. He addresses Curtis Wright. He says there's a lot of broad dicta in Curtis Wright, but the holding of Curtis Wright, the ratio dissidenti, is that the domestic non-delegation doctrine does not apply with the same force in the foreign context. And then he uses that phrase, does not apply. He says the strict limitations on delegation that apply, in the internal context do not apply in the external context. And so we rely on that line of cases. And for the reasons I talked about earlier, where we're talking about a situation where the president has his own inherent authority to address foreign arising emergencies, and Congress is conferring tools on him that expand his ability, his capacity to do so, we are in the area of Youngstown Zone 1.
A few times you have alluded to the history as being important in interpreting the statute, and also that this language comes from the Trading with the Enemies Act, and that has its own pedigree. Could you just sketch out this direct line that you were alluding to as a basis for interpreting the current emergency statute as you would like it interpreted?
Yes, Justice Thomas, and turning back to the response I was giving to Justice Barrett earlier, there is, I think it's very well set out in Professor Baumsei's amicus brief, there is this history of presidents using a tariffing power or a tariff equivalent power, very, very close to tariffing power, in wartime to tariff trading with enemies. And that is when the Trading with the Enemy Act was enacted in 1917, it was deliberately evoking that. And when it brings in the power to regulate importation, it's essentially codifying for the inherent power the president's already recognized to have. And then in 1933, when that power is expanded to an area where he wouldn't inherently have it, the peacetime context, that codification, the meaning of that remains the same. The regulate importation language that's brought in from TWIA and then ultimately to IEPA in 1977 is carrying with it that connotation, and that's reinforced by all the cases we've cited in our brief where there's been extremely broad delegations of the power to tariff specifically and the power to regulate foreign commerce more generally, going back to the time of the founding, which ties to your question about non-delegation.
Justice Alito?
The court of the CCPA said things in Yoshida that are helpful to your position, but it also said some other things. It said that future surcharges, quote, must of course comply with Section 122 of the Trade Act of 1974. It said that the Trading with the Enemy Act did not authorize the president to, quote, fix rates of duty at will without regard to statutory rates prescribed by Congress. So do you think that Congress, to the extent Congress had that decision in mind and relied on it, do you think it also relied on those statements in the opinion?
Not in the same way, because those statements are read into other provisions of TWIA that Congress did not enact in a NEPA. They may still be there in TWIA, but those are limitations that it wouldn't make sense to do. And I think the significance of Yoshida is at a higher level. Keep in mind that their principal position is no tariffs at all. Regulated importation just doesn't carry a connotation of the power to tariff. And we say we've got historical sources going back to Gibbons against Ogden that say the opposite. But more fundamentally, everyone knew that at the time IEPA was enacted, that regulated importation had just very visibly and very prominently
Hey, Kathleen.
been held to include a sweeping global tariff.
Thank you. Mrs. Sotomayor?
I'd like to go back to Justice Barrett's question on the word license as used in AEPA. It's not used as a verb, it's used as a noun. By the President may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, then do what the verbs permit him to do. By license, he can nullify, void, prevent, or prohibit any acquisition, etc. So license is not being used as a verb that through licensing he can raise revenue. He can only use licenses to accomplish the verbs. So I don't understand how we can treat licensing as equivalent to revenue raising. It, as used in IEPA, the license is only to accomplish what B permits.
In Hamilton against Dillon, licenses, once you had the license, then you had to pay the fees.
But that's the point I'm making, which is that the only use of license here is a noun. You can license to accomplish the powers that B gives the president.
Let me be clear, we rely on the phrase regulated importation. We're not saying that
Exactly.
executive
You're
order
not relying on licenses for that reason.
No, I only cite that language, that introductory language about, instruments, licenses,
That
other
you
or otherwise,
can't rely on
as
opinion.
another layer of breadth in this particular
Counsel, would you listen to my question? You're not relying on license for the reason I just said.
Stop
because
trying to
it
fast
is
talk.
a noun, not the verb. You're relying on regulate, correct?
Yes, we're relying on regulated importation.
And despite the fact that no other president in the history of AEPA has ever used tariffs as a power under AEPA.
Well, President Nixon did so
Under a predecessor, and we have all the limitations of that. All right. Number two, whenever Congress intends to permit taxing and regulate, it uses the word tax and regulate in every other statute, correct?
I don't concede that. I mean, two very visible examples again are TWIA and Section 122.
We're back to the question here. Okay, thank you, guys.
Justice Sotomayor?
No, she's Justice Sotomayor. She just finished.
Justice Kagan?
General
And they're friends?
I want to take you back to Justice Thomas's question about non-delegation, and if I understood your answer correctly, it was really similar to the answer that you started off with when you talked with Justice Thomas about the major questions doctrine, which is sort of everything's different because the president has independent constitutional powers in this area. And so that if one does not think that with respect to tariffs, if one thinks that a tariff is a taxing power, is a regulation of foreign commerce that is really delegated by the Constitution to Congress, that argument does not sound so well. And in fact, when you look at J.W. Hampton, which gives rise to the non-delegation test that we usually use, J.W. Hampton is a tariffs case. And the court did not say, oh, we need some special new principle here, some stricter rule because we're dealing with tariffs in which presidents are directly concerned as a matter of foreign relations. It enunciated the test we use for all non-delegations. So how does that fit with your theory?
8 years later, in Curtis Wright, the court held the non-delegation doctrine for domestic affairs does not apply with the same force as it does in
But
foreign
not
affairs.
with respect to tariffs, not with respect to quintessential taxing powers, which are given by the Constitution to Congress.
I think justices of this court have recognized in their
Aditorio.
opinions that one of the reasons that the non-delegation doctrine that intelligible principle test hasn't packed as much punch as Justice Kavanaugh cited in one of his opinions as it might otherwise have done, as it did arise in the foreign affairs context, because there the court has historically been very, very comfortable with very broad delegations. Chicago and Southern Airlines, another case from the 1930s, shortly after J.W. Hampton talked about the very large delegations for foreign commerce power being very effective. And of course, this goes back to the very dawn of the Republic in 1790, for example. Congress conferred on President Washington basically the entire Indian commerce power. Is that go, get licenses, right, to do commerce with the Indians, and they'll be subject to whatever rules and regulations President Washington can make. So I do think there is a profound consistency between the announcement of the intelligible principle test in J.W. Hampton and then the subsequent recognition by this court in Curtis Wright that the non-delegation doctrine doesn't apply with the same force in this context.
In consumers research, just last year, we had a tax before us, and the question was this a delegation issue? It was, of course, a much smaller tax, which dealt with many fewer taxpayers. Notwithstanding that, we said if there's no ceiling on this tax, we sort of assumed that if there were no ceiling on this tax, it would raise a delegation problem. And most of the opinion was given over to showing that there in fact was a ceiling on the tax, not a quantitative one, but a qualitative one. But how does your argument fit with the idea that a tax with no ceiling, a tax that can be anything, that here the president wants, there an agency wants, would raise a pretty deep delegation problem?
First of all, I can't say enough. It is a regulatory tariff, not a tax. And that, I think, ties to my response to that, which is that this is a totally different context. This is IEPA, a statute that Congress carefully crafted to grant the president admittedly broad powers to address foreign arising emergencies. It's outward-facing to foreign affairs, where there's the broadest level of deference to the political branches. This court has recognized in many cases. And it imposed not a floor or a limit on the amount of a tariff that could be imposed very naturally, because, for example, as this court said in Loving, quoting, Alexander Hamilton in the Federalist number 23, it's impossible to foresee either what exigencies may arise or what tools may be needed to address those exigencies, the means that may be required to address those exigencies. Instead, Congress grant very broad powers, but they're confined to a particular domain. This domain is any property in which any foreign government or any national thereof has any interest. So the sort of discipline, if one were to apply, we say you shouldn't, but if you would apply the non-delegation doctrine, the domestic-facing non-delegation doctrine in this context, there's a significant limitation there.
Yeah, so my last question really does have to do with that point, which is how or whether this is confined. Because if you look at Title 19, which is loaded with tariffs and duties of various kinds, all of them have real constraints on them. They are, you can't go over X percent, or it can't last more than 1 year. And of course, the way you interpret this statute, it has none of those constraints. And the question arises why it is that any president ever would look to the tariffs in Title 19 if sub silentio, if you will, this statute gives the president the opportunity to blow past those limits.
Victoria, the tariffs is taxes coming out of our pocket. So he wants to take away snaps, he wants to take away health care and increase it. I mean, just to name a couple, just right off the bat. And then you want us to pay more taxes on deals, foreign deals that he's made. Like they have to buy into his coin, his Trump coins, and they have to put X amount of dollars in his pockets. No.
And in fact, we've had cases recently which deals with the president's emergency
because
powers,
we pay for that on the back end.
Everything all the time about like half the world.
No. Absolutely not. And it's not his power to enforce. No.
Which, we had an agreement last week to create
absolutely
which illustrates the effectiveness of the tariff.
Need to take a seat.
But the point I would make in response to that is those are, even if there's limited judicial review, which is very natural in the foreign affairs context, this court has always granted the president the presumption that he's acting in good faith.
Our eyes are open.
Extraordinary threat that that arises
right about now. So all of his little tricks and tactics are getting caught.
economy or foreign
Release
policy of
the
the United
Epstein
States. So
files.
there are those. Then there's 1701B,
And
which
then
talks
you
about
would
how
be,
it's to be used for
you
this
know,
and
you would
no other
stop
purpose.
coming
Then
up with these
limitations in section
little
1702B.
tactics,
Then there is the
you know, to
limitations I referred to
stall or
earlier
to
about
take
what you
our
can
minds
actually do.
away
You do a heck of
from
a
the
lot,
Epstein
but
file.
everybody's
It's not
dealing with
going
problems
anywhere.
which foreigners have
We
an
want
interest in. That's a
justice for the
pretty
kids
narrow domain. That's
and the
quite siloed,
adults,
so to speak. And then, of course, overarching it all, there's
girls and
congressional oversight.
boys.
And you may say congressional oversight may not have much bite, but Congress didn't think so. Congress crafted this compromise. It balanced the never-ending tension. When it drafted AEPA, it had its eyes open. As the dissent below says, its eyes open looking at the problem of sweeping emergency powers for an executive who may use them in a way that's excessive versus the need to address unforeseeable
Thank you,
emergencies.
General.
Justice Gorsuch.
General, just a few questions following up on the major questions discussions you've had. You say that we shouldn't be so concerned in the area of foreign affairs because of the president's inherent powers. That's the gist of it, as I understand it, why we should disregard both major questions and non-delegation. So could Congress delegate to the president the power to regulate commerce with foreign nations as he sees fit? To lay and collect duties as he sees fit?
We don't assert that here. That would be a much harder case now. In 1790.
Isn't that the logic of your view, though?
I don't think so, because we're dealing with a statute that was a carefully crafted compromise. It does have all the limitations that I just talked about.
You're saying
it
we
has broad
shouldn't
powers
look,
in
we
this
shouldn't
area
be
of
concerned with, I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the president has inherent authority, and so delegation off the books, more or less. And if that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president?
We don't contend that he could do that. If it did,
why not?
Well, because we're dealing with a statute again that has a whole.
I'm not asking about the statute, General. I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions in non-delegation, what bite it would have in that case.
I would say by then you would move from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties, and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say we are not here to judge metes and bounds when the foreign affairs. That's what I'm struggling with. You'd have to have some test. And if it isn't the intelligible principle test, or something more with more bite than that, you're saying it's something less. Well, what is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right to approach it is a very, very deferential application of the intelligible principle test, that sort of wholesale application of...
All right, so now you're admitting that there is some non-delegation principle at play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential. Okay. Limited is what, and again, the phrase that Justice Jackson uses, it just does not apply. At least
I know, but that's where you started off, and now you've retreated from that, as I understand it.
Well, I think we would, as our frontline position, assert the stronger position, but if the court doesn't accept it, then if there is a highly deferential...
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
Well, we don't contend that. Again, that would...
Well, you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now you're... I think you... tell me if I'm wrong. You backed off that posision.
Maybe that's fair to say.
Okay, all right.
Maybe that's fair to say.
That would really be an application.
Yes.
I'm delighted to hear that, you know. All right, and I wanted to return to something Justice Sotomayor asked under this statute, okay? So now we're in the statute. It's a major question, though. Could the president impose a 50% tariff on gas-powered cars and auto parts to deal with the unusual and extraordinary threat from abroad of climate change?
It's very likely that could be done. That's very likely.
I think that has to be the logic of your view.
Yeah, in other words, obviously this administration would say that's a hoax, it's not a real crisis, but...
I'm sure you would.
Yes, but that would be a question for Congress under our interpretation, not for the courts.
All right. And then on this inherent authority idea, I understand the president's inherent authority in wartime, and a lot of your examples of regulating commerce, and maybe your best one, Hamilton, during the Civil War, they occurred during wartime when the president's commander-in-chief power is clearly in play. Does the president have inherent authority over tariffs in peacetime?
No, we do not contend that.
Okay.
And in fact, and I'd cite, if I may, I'd point the court to two cases. They're Loving against United States and then Masery that's cited in Loving. Those are situations where...
Hello, I'm Ana Cabrera. Reporting from New York, you've been listening in now to about an hour of the arguments before the Supreme Court dealing with the legal authority of the president to enact his sweeping tariffs. And I want to bring in our great panel of experts just to get a little bit of analysis of what we've been hearing, what the questions mean, the arguments from the administration, which is the only side we've heard from so far. We'll go back in momentarily to hear from the plaintiffs. But joining us again is Lisa Rubin, Ron Insana, Catherine Christian, and Chuck Rosenberg. Pick up where we left off before these arguments. And Catherine, let me start with you. Just initial thoughts on what stood out so far.
Well, he's still speaking, but Justice Gorsuch just asked, could a president impose a 50% tariff on gas-powered cars due to climate change? I think, and I could be reading this wrong, that's sort of a message to Republicans. You know, you might get a Democrat in who really thinks this climate change is horrible and imposes a 50% tariff. So be careful what you ask for. I could be simplifying that. And
But
also,
the fact that that is coming from Gorsuch is also notable.
That's, I think his way, and Lisa, I think, wrote about this, of saying, hold your horses here. And obviously Sotomayor, when she started off the bat, I just don't understand this argument. A tariff is a tax, period. And I asked Ron, is there any economist that says a tariff isn't a tax? And he said no. So it's not my area, but I always thought it was a tax.
Broad takeaways, Ron, for you?
Yeah, look, I mean, unfortunately, they're not dealing with whether or not there is an actual economic emergency that is, foundational to other questions about the presidency. I wish they were dealing with that because the president has cited multiple emergencies for the imposition of this particular set of powers.
He's talked about the fentanyl crisis and the trade deficit. Those are like the two key pieces
And
of
also talked
emergency
about
justification.
raising revenue and using it as a bargaining chip in trade negotiations with other countries, all of which appear to be the trade deficit itself being the central emergency here, which we've had trade deficits since the 1970s. We've had tariffs at 5% or under since 1970 with no economic emergency that resulted as a consequence of this. So when he says, if this is overturned, we're going to have something like the Great Depression, quite the opposite was true. It was the imposition of tariffs during the Great Depression that worsened the downturn. So there were all these
and that's what we expect from the plaintiffs to say, in part, that the tariffs have actually created a national emergency
and raised inflation by and large.
And we'll have more to discuss about that. Guys, we have some important questioning happening right now. Let's go back in.
Can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that political oversight
with the president's assent.
Meaningful.
With the president's assent, in fact,
Once he lost it by a veto-proof majority in the Senate, I think the position. I think he realized, and that's the political process working. There was a political
it takes a supermajority, a veto-proof majority to get it back. Yeah. Okay. One other question. Do you think tariffs are always foreign affairs?
I do think they would. I can't think of a situation where they're not foreign-facing. If you're talking about tariffs on imports, I mean, maybe there are other tariff contexts that I'm not aware of, but yes, they typically would involve.
And we pay the taxes. Hey, Natural in New Orleans.
If they are revenue-raising tariffs, they would not raise the same.
And we pay the taxes.
Issues as regulatory tariffs, which are imposed not for the purpose of raising revenue, but to induce foreign powers to change their behaviors.
So revenue-raising tariffs are not foreign affairs, but regulatory tariffs are.
I don't think a revenue-raising tariff would be foreign affairs to the same degree, at least. I think it has a foreign application, obviously, but I don't think it would raise the same issues.
Okay, thank you, General.
Justice Kavanaugh?
Figuring out what regulate importation means is obviously central here, and for major question purposes, I think the way we think about that kind of question is, does the specific authority, power, major power, now asserted pursuant to that general statutory authorization, was that the kind of power that would have been understood by people, by Congress at the time the general statute was passed, as distinct from being a novel kind of use of that general authority to do something different? Unheralded is the word in our cases. Okay. One problem you have is that presidents since IEPA have not done this. Your primary answer, or one of your many answers to that, is the Nixon example. And that's a good example for you, because Nixon relied on regulate importation to impose a worldwide tariff. Good example. What is our understanding of Congress in 1977 vis-a-vis
Hot Southern
that
Queen.
Nixon
Thank
example
you.
when Congress reenacts
Thank
or
you.
enacts the regulate importation language into IEPA?
Congress at that time was fully aware that a Court of Appeals with exclusive jurisdiction had interpreted that very phrase very visibly, very prominently, to include the power to tariff, and then reenacted it without change. The court addressed a kind of lesser situation in Algonquin when it came to Section 122, and the court said President Nixon interpreted this to include a tariffing power, a tariffing-like power, and then Congress a few months later reenacted the language without change, and that's powerful evidence of congressional acquiescence. So that immediately historical background is very powerful, and it's buttressed, of course, by sources going back to the founding, where we say the phrase regulate importation.
Thank you, Naturally Norlis.
That is the power to tariff.
Thank you.
That's how you regulate.
Why, this may require some speculation on your part, economic philosophy, etc., but I'll ask it. Why do you think Presidents Clinton, Bush, Obama have not used IEPA to impose tariffs on, because there have been trade disputes, and certainly, you know, President Bush, steel imports and the like. Why do you think IEPA has not been used?
If you look at those 69 emergencies, in fact, you go through them one at a time, which we had our team do, it's really hard to find one where you look at that emergency and you say, oh, tariffs is the natural tool you would use to address that emergency. So, for example, the Blood Diamond emergency, tariffing these sort of, criminal organizations in Africa that are financing terrorism through the sale of diamonds, you don't really tariff them. Or you take, the Iranian hostage crisis. President Carter didn't say, oh, you seized all of our, embassy personnel, you're holding them hostage, we're going to tariff you, right? And if you go through those emergencies, there are two emergencies, though, where tariffs are the obvious natural tool for a president to use. One is the Nixon balance of payments deficit problem, and the other is this particular emergency. And also there's political reasons. I think that it's no question that President Trump is by far the most comfortable with the tariffs as a tool, both of, economic and foreign policy, than many of the others presidents may have been. I mean, there are presidents like President Bush
answer the question.
Wouldn't have naturally, selected that particular tool or method. But if you go through all 69 of those intervening emergencies, what they have not done, at least, is they have not identified where they say, oh, here's one where tariffs would have been the obvious tool, but the president didn't use it.
Algonquin, as you've mentioned many times, is obviously very important here for us to understand exactly what's going on in Algonquin. The phrase there is different, adjust imports, and they really, the other side, your friend on the other side, really relies on the difference in language. And I just want you to give your best answer to why regulate importation encompasses tariffs when we held that adjust imports would encompass monetary exactions.
Three answers, if I may. Adjust is narrower than regulate. And so, therefore, the greater includes the less. Second answer, adjust is the second Black's Law Dictionary definition of regulate. The Black's Law Dictionary, our original plain meaning dictionary definition, says adjust by rule, mode, or rule, method, or established mode. So there's just a plain meaning link there. Regulate, adjust is a kind of regulation. And then I think far more importantly, regulate importation. I can't emphasize enough. Going back to the time of the founding, has been understood that the manner in which you regulate importation, the natural way to do that is to tariff. So it'd be textually astonishing, given that historical pedigree, going back to Gibbons, going back to, Madison's letter to Cabell, and all the historical sources cited in our briefs. It'd be kind of astonishing to say, hey, President, you can regulate imports, but we're not saying this explicitly, but you do not have the power to tariff, when the tariffing is, in many ways, the quintessential way of regulating importation. So that historical pedigree sort of gives freighted meaning to that two-word phrase.
And last, you had some discussion about license fee versus tariffs, if there's a distinction. I mean, the counsel in the oral argument, Algonquin said they're all monies exacted on imports, so in that sense, it certainly is a tariff, and hence all the incidents and the economic effect of a tariff. But we can't rely on what the counsel said in Algonquin. Isn't there a difference of sorts, at least, between a tariff and a license fee? You answered this, I think, briefly before, but I want to make sure, because I think this could be an important point, because I want to know Algonquin to decide this case. So give your best shot on that.
I agree that there is, there's a formal distinction. But as a practical matter, I think what counsel was probably arguing there is that there really isn't much of an important distinction. And I would point to the passage in Algonquin where the court says, look, they've conceded that this includes the power to quota, and since quotas are a quantitative method, it would make no sense for Congress not to grant the qualitative method, and all the more so here if there's a concession, as they do in some of the red.
One time the court said monetary methods, i.e. license fees, and the next page said monetary exactions, i.e. license fees and duties.
I think the court bought the
It's important to be consistent.
that there's really not a lot of daylight between those two. As a practical matter, certainly almost no daylight. And so then the question...
When you say almost no daylight, just...
I would say that they're economic equivalents. Legally, they're pretty much the same, so I really don't see a big distinction there. And of course, the logic of Algonquin was, quantitative methods quotas are allowed. Therefore, it would make no sense at all to interpret this not to include the qualitative or the monetary exaction methods. Well, if we're talking about a distinction between regulated importation, including licenses that can come with fees, but not tariffs, that logic applies all the more so.
Thank you.
It makes no sense.
Justice Barrett?
Well, I think in Algonquin, there was a formal distinction that mattered because at that oral argument, counsel pointed out that the uniformity clause would kick in and the constitutional uniformity requirement would apply to tariffs if it was that way, and speculated that the reason that the government may have set it up as a licensing scheme with licensing fees was to avoid that. So I do think there are some distinctions, but keeping that in mind, if you say that there really is, as a practical matter, no difference, this is kind of what I'm hung up on in license that maybe you can help. So in IEPA, Justice Sotomayor is right, license is used as a noun, but it's one of the means necessary. So in Algonquin, it was by any means necessary adjust. Here the statute says the president may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, regulate importation, which is the key part for our purposes. So the means it specifies are instructions, licenses, or otherwise. So I think it would, one argument might be that it would have been natural for Congress to put the president may, by means of instructions, licenses, tariffs, or otherwise. With an adjustum generis thing, I think you have to rely on the or otherwise, picking up more. Or if there really is no practical difference between licenses and tariffs, why aren't you making the argument, or why didn't the president structure this as a licensing fee scheme? How do I understand that language?
Who write the
or am I
laws?
just misunderstanding it in this language?
Do
is
the
totally
president
wrong?
write the laws?
Here's the way I'd respond to that.
Oh, Congress.
I think that language powerfully reinforces our position as the way you've laid it out right there. Because, first of all, regulated importation, we say, and based on extensive historical pedigree, the core application of that is tariffing. To list tariffing again would have been essentially redundant and unnecessary, especially if you look at the specific historical background of TWIA, where TWIA was enacting a tariffing power or a licensing-like power, that was described as, again, duties and tariffs equivalently.
Okay, but I don't understand.
Okay,
I think you
so
have to
if
put
Congress
together
write the laws,
A1
how
and
are
then
you arguing
B. So I think what you're
interpretation
saying is
when
he may
Congress wrote
prescribe by
the
means of
law?
tariffs,
If you would go
tariffs.
through Congress,
saying is
you
by
would
means of
know
Instruments,
the law.
licenses, or
By
otherwise.
instructions,
I love
licenses,
you.
or otherwise.
Instructions,
Impose
license,
tariffs?
otherwise.
Okay.
That otherwise, if you say instructions, license, or otherwise, and we're asserting
But the
power,
problem
that's very,
is you want to
similar
bypass
licensing.
Congress
Otherwise,
because
naturally carries
they
with it.
wrote
That's
the
our
law,
principal position.
so
Our
they
principal
know
position
the
is
law.
that.
I mean,
You don't need to say it again. However, if Congress has authorized them to do it by licenses that could come
Congress
with
wrote
fees
the
that
law,
economically
not
produce,
Trump.
and then says otherwise, that just reinforces
This is kind of the bottom line. But that's why you want to bypass them, because you don't want to follow the law that they wrote.
You said, well, listen, you point to the Congress's ability to terminate emergencies, which it's done. But if Congress ever wanted to get the tariffing power back, it would have to have a veto-proof majority because regardless of the emergency, so if Congress wanted to reject the, let's say that we adopt your interpretation of the statute. If Congress said, whoa, we don't like that, that gives a president too much authority under IEPA, it's gonna have a very hard time pulling the tariff power out of IEPA, correct?
I don't know if it'd be a hard time. Certainly we'd have to have a
veto-proof
statutory
majority.
amendment, which would be the true of any case where this court definitively interprets a statute. Yes, I think that the
But
Congress have to pass
definitively
a statute.
interpreting a statute that grants presidential power makes it particularly hard to get the president to not want to veto something, which, as Justice Gorsuch is pointing out, has him lose power. All right, I want to ask you a question about unusual and extraordinary threat, which we have not talked about yet, and I specifically want to talk about the reciprocal tariffs. These are imposed on, these are kind of across the board. And so is it your contention that every country needed to be tariffed because of threats to the defense and industrial base? Spain, France, I could see it with some countries, but explain to me why as many countries needed to be subject to the reciprocal tariff policy as are.
Yeah, Executive Order 14257 spells out the nature of the emergency and basically says that there's this sort of lack of reciprocity, this asymmetric treatment of our trade with respect to foreign countries' trade that does run across the board. It is a global problem. And then that puts in context the argument they make that this power to tariff is so broad because you're applying to every country in the world. That conflates the nature of the tool, tariffing, which they're challenging here, with the nature of the declared emergency, which they haven't disputed. They haven't disputed, for example, that the president has correctly identified that virtually every major trading partner has this long-standing, sort of asymmetric, unfair treatment of our trade. So the argument this power is so broad, is really based on a conflation of two different things. One is the power, right? Imagine this. Imagine that, for example, President Reagan had wanted to convince South Africa to change its
why
apartheid
everyone
policies,
will get
and he'd impose tariffs on
confused.
them.
No king
No one better
in the
than I should say, well,
USA.
that's
Right.
too broad. That's too broad. That can't be an IEPA.
Congress
The power
needs
to
to
tariff
do their
is sort of
job.
fits naturally with
These
all those powers
branches
to
of
block prohibited
government
seas and so forth.
is
They're
what
saying
we
this is so broad because
have,
the
but Trump
emergency is so
doesn't
broad.
want.
But of course, that's a presidential determination that,
So
and
who
there's
runs
all
the
kinds of basis for it. And also, keep
financial
in mind
of
that
the
the emergency is
country?
not like just the asymmetric treatment, it's the
Executives
impact of the
of the
asymmetry, the underlying conditions, the hollowing out of our
judiciary.
manufacturing base, the vulnerability of our supply chains, and of course, our defense industrial base's vulnerability of key inputs.
Justice Jackson?
So as I understand your response to Justice Barrett in that last question, you're saying that the power to tariff fits naturally with the power to block and seize. That was your example. But I guess I'm trying to understand then your argument from the text of the actual statute. Because the statute, unlike what you suggested to Justice Kagan, is focused on the actual actions that the president can take. In response to Justice Kagan, I understood you to say that Congress was giving the president broad authority to act, and it was within a particular domain, which is the domain of emergencies with respect to foreign power, but the president could basically do a lot of things. But when I read the statute, it is telling the president exactly what he can do. Investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit. And I guess what is a little concerning to me is that your argument suggests that we should see the word imposed, the phrase imposed tariffs in that same series of things that the president could do. We don't see that word, and instead you take regulate and say that must mean that. So I guess I'm getting back to Justice Barrett's maybe original question, which was where else in the code has Congress used the word regulate to sub in for imposed tariffs?
TWIA, and then this court's opinions, of course, have used regulate and import, or have pointed out that duties are the natural way to regulate foreign commerce.
But you're saying we should not have expected to see the same level of granularity with respect to the president's authority to impose tariffs as we see here investigate, block, direct and compel, nullify, etc.
I think it would be very unusual for Congress to spell out all the ways that you can regulate in that
So
statute.
regulate becomes a big catch-all. The rest of the other things,
Well, I mean, that we have a concession of that from the other side, that regulate at least includes qualitative methods, quantitative methods, quotas, licenses. They would concede that regulate, there's a lot in regulate that's not spelled out there. And our point is, you don't need to spell out tariffs, because that's like, of all of them, the most natural, the most quintessential method of regulating
and yet,
imports.
and yet, many presidents have not used regulate in this way to impose tariffs. I
Right.
understand you point to President Nixon. We have licenses from Lincoln, but
As
no
I
one
said,
else.
Justice Kavanaugh, presidents who are faced with international crises to which tariffing is the natural response. That's President Nixon and President Trump have invoked this authority. And also, frankly, President Trump invoked this authority.
Wasn't Nixon impeached for
Can I ask you one question?
Watergate?
Let me just ask one more question
Stealing and
about
stealing and
the
stuff.
unusual threat. So in your conversation with Justice Gorsuch, that we had the climate change tariff hypo, and you indicated that there would be challengers to the notion that that was an unusual and extraordinary threat. And I'm just wondering, under your position, would they be able to make a legal challenge? Are you saying the court would not be able to review?
On that particular hypothetical, I think I said that'd be a question for Congress.
So not a
Yeah, in other words, that wouldn't be the sort of thing the courts would want to wade into. Is this really an emergency? That would not be probably very unlikely. That'd be a situation where at least there'd be very, very, very deferential judicial review of that kind of determination.
No, I'm asking
Legal
you.
makes dispute.
Right, those are two different things. Is there no judicial review, or is there deferential?
Our frontline, Trump against Hawaii, our frontline position is that it falls within Dalton against Specter. It's committed to the president's discretion when he makes his determination of a national emergency. But the court doesn't have to decide that because whatever review is very, very deferential. It's easily satisfied here.
Thank you.
Thank you, counsel. Mr. Contio?
Thank you, Mr. Chief Justice, and may it please the court. Tariffs are taxes. They take dollars from Americans' pockets and deposit
Absolutely.
them in the U.S. Treasury. Our founders gave that taxing power to Congress alone. Yet here, the president bypassed Congress and imposed one of the largest tax increases in our lifetimes. Many doctrines explain why this is illegal, like the presumption that Congress speaks clearly when it imposes taxes and duties, and the major questions doctrine. But it comes down to common sense. It's simply implausible that in enacting IEEPA, Congress handed the president the power to overhaul the entire tariff system and the American economy in the process, allowing him to set and reset tariffs on any and every product from any and every country at any and all times. And as Justices Gorsuch and Barrett just said, this is a one-way ratchet. We will never get this power back if the government wins this case. What president wouldn't veto legislation to rein this power in and pull out the tariff power? IEEPA is a sanctioned statute. It's not a tax statute where Congress gave away the store. Congress knows exactly how to delegate its tariff powers every time for 238 years. It's done so explicitly, always with real limits. IEEPA looks nothing like those laws. It uses regulate, which Congress has used hundreds of times, never once to include tariffs, and it lacks the limits of every other tariff statute. And that is why, even though presidents have used IEEPA to impose economic sanctions thousands of times, no president in IEEPA's 50-year lifetime has ever tried to impose tariffs. And the president bypassed statutes that do address tariffs, like Section 122 for large and serious trade deficits, but that imposes a clear guardrail, 15% cap, 150-day limit. This is Youngstown at its lowest ebb. If the government wins, another president could declare a climate emergency and impose huge tariffs without fines or without floors or ceilings, as Justice Gorsuch said. My friend's answer, this administration would declare it a hoax. The next president may not quite say that. This is an open-ended power to junk the tariff laws and is certainly not conveyed by the word regulate. I welcome the court's questions.
Wouldn't your argument also apply to embargoes?
So, and this is the argument in the fine dissent below, and I think there are three answers to that, Justice Thomas. The first is revenue raising. Embargoes stop the shipment. Tariffs
change the laws before you break the laws.
Regulating revenue, as some of your own opinions said.
If you think
this is
it's
the way
not
we actually
appropriate
chiefly
and
got
need to
revenue for the
change,
first 100
get it
years,
changed in
of our
Congress
republic.
first
Tariffs
before
are
you
constitutionally
break the
special because
law.
our founders feared revenue
Period.
raising, unlike embargoes. And, you know, there was no Boston embargo party, but there was certainly a Boston Tea Party.
You can't break the
Secondly,
law and then say it
textually,
needs to
in
be
the statute,
changed.
it's different. Regulate appears in a cluster of verbs, as was said before: investigate, block, nullify, and the like. They describe embargo-like controls, prevent and prohibit, for example. But they don't describe revenue exactions. That's Justice Kagan's point. The
That's
one
just an
verb
excuse.
that's missing here is anything about raising revenue whatsoever. Another point, congressional displacement. Today, there's a whole host of statutes in the tariff architecture of Title 19, which both expressly confer the power to tariff and always impose clear limits. Embargoes by the president, embargoes don't have any of that. They don't set aside that whole thing. If you look at the Learning Resources brief at page 5, it goes through these statutes in detail. Section 122 expressly says duties and then limits it, 15%, 150 days. Section 201, any duty on the imported article, but it requires ITC findings. Section 301, impose duties. That's the language of the statute, but all sorts of procedural restrictions. Section 338, the same. I can go through this, and I could start, by the way, Justice Thomas, with the statutes at the founding, all of which expressly said the word tariff or an equivalent.
Let's go back to your non-delegation point. It would seem that if it's if the tariff power cannot be delegated, your argument on non-delegation would also have to apply to embargoes and to quotas.
No, Your Honor, because I think tariffs, because they're uniquely revenue raising, impose special, unique concerns that go back to our founding. And so I don't think that they apply to embargoes. And indeed, the history of this is very clear. That, as you just heard my friend say, in 1790, George Washington was delegated massive embargo power from the Congress. But what did Congress not do? And this is why the example cuts the other way. They never gave the president any sort of delegation of tariff authority at the time. Our point is not you can't delegate tariff authority. It's simply that you've got to do so with intelligible principles. And what you just heard my friend say is every single limit in IEPA is one that is not judicially enforceable. There's no limit whatsoever. And indeed, the main limit that was in there, he calls this some compromise position. The only compromise in 1977 was the legislative veto. And as this case comes to the court, that's no longer in the statute at all.
Counsel, yes, sure, the tariffs are a tax, and that's a core power of Congress. But they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry. Were quite effective in achieving a particular objective. So I don't think you can just separate it when you say, well, this is a tax, Congress's power. It implicates very directly the president's foreign affairs power.
Mr. Chief Justice, we don't disagree with a large part of that. We think instead of thinking about foreign versus domestic, the better way of thinking about it is Article 1 versus Article 2. And as my friend finally conceded to Justice Gorsuch, there is no Article 2 power here, at least when we're talking about peacetime.
Well, you don't agree with a large part. What's the little part that you do disagree?
So we agree with the idea that tariffs have foreign policy implications. Absolutely. Our founders recognize that. That's in the Federalist Papers. But nonetheless, they exclusively committed that power to the Congress in Article 1, Section 8, and gave it as its first power. So when you hear my friends cite cases like Egan and Garamendi, they just don't apply to this specific, unique situation in which Congress is given that power. And if you were tempted by this, I think the best place to look is Youngstown, because what Justice Jackson said, and I was surprised that he
Who
quoted
paid the
652,
tariff
because
tax?
What Justice Jackson said is, quote,
Do the
"Emergency
foreign
powers
country
tend to kindle
pays it
emergencies, so
that
it's
he
essential
impose
the
it
public
on,
may know the
or the
extent and
United States?
limitations of the powers that can be
Taxpayers.
asserted, and persons affected may be informed from the statute of its rights and duties." And Justice Jackson went on to say there that it's notable our founders didn't give the president revenue-raising power even in a time of war.
Can I just get a clarification of your answer, which is You agree if the word tariff were in the statute, that would be acceptable and constitutionally permissible, correct?
No, it would be, it'd be constitutionally permissible. The question would then be, is the open-ended assertion of power here? Because every
Right,
other
I get
statute
as
has
applied to this
limitations.
case, but the general point is, yes, Congress, you said it's assigned to Congress, but Congress can grant authority to presidents to impose tariffs
Absolutely.
as a general proposition. Okay, so we have to figure out then what regulate importation means. And you've heard my questions. If this statute came out of nowhere in 1977, I think your case would be, obviously stronger. We have to figure out, at least I want to figure out what the Nixon precedent stands for and what Algonquin stands for. On the Nixon precedent, the question is, I think, was Congress aware of that, meaning that when they used regulated importation and it's now being used to encompass tariffs, that's not unheralded because Congress was well aware. President Nixon announced those tariffs in a nationwide primetime speech, 10% across the board in August 1971. It was not some kind of little piece of paper. So it was well known. The question then is, was Congress, why didn't they change the language? Why didn't they say regulate but not tariffs? That's kind of the difficult question from the Nixon precedent that I'll give you an opportunity.
Thank you, Justice Kavanaugh. So 5 answers on the Nixon precedent. First, there is no evidence that Congress thought it was ratifying Yoshida. It was a single Court of Appeals case.
It's not some my question, I never mentioned Yoshida. It's the use by the president of that power under regulated importation.
Oh, if we're just talking about that, President Nixon did not rely on the statute whatsoever. And that's very clear. In fact, we have a Marshall McLuhan moment here because you have before you Alan Wolf, the person who was there in the room with Nixon, saying Nixon totally disagreed that this statute applied. So if we're just talking about Nixon, I don't think it can get the government where...
Go to your other four.
So I think the only way it does any work is if the president is through the vehicle of Yoshida, and that's what I take it the government is arguing. And with respect to that, this cert-denied intermediate court of appeals decision, I don't think it can come close to overcoming the clear, plain text. The word regulate words regulate importation. The word regulate has never been used. The Congress uses the term 1,499 times. We got about that number of hits when we looked at it. And maybe there's some double counting, but it is never used even once to impose taxes or revenue raising. And that was the question that Justice Barrett was asking. And so I don't think that this intermediate court of appeals decision will get you there. And then even if you thought that Congress knew about Yoshida, and even if you thought they liked it, which there's absolutely zero evidence of, I don't think that helps the government for reasons that Justice Alito was pointing to, because Yoshida said 3 things. A, TWIA doesn't give the unlimited authority that the government is seeking here. B, they were only upholding the limited specific assertion of authority that President Nixon sought there. And third, going forward, the solution, they said in footnote 33, was to use Section 122 of the 1974 Trade Act, 15%, 150 days. So we have no problem with the president doing that. It's just that this president has torn up the entire tariff architecture. For example, he's tariffing Switzerland, one of our allies, which we have a trade surplus, 39%. That is just not something that any president has ever had the power to do in our history. And the idea that Congress, by implication, did this in 1977 and handed him all this power, I think is really difficult.
Just to ask the other, go ahead.
Let's start with just the bare statutory language. You have arguments about structure, you have arguments about history.
Yeah, he all over the place. Sometimes it sounds like he speaking against his plaintiff. He confused me.
If we disregard all of the rest, would you dispute that would include the imposition of a fee?
So if it's revenue, yeah, we do dispute that, absolutely.
What if there were a statute that said, suppose that there's a particular national park that's very crowded, and Congress passes a statute that says the National Park Service may regulate admission to the park. Would you say, well, that does not allow them to impose a fee?
So, Your Honor, sometimes we think of fees as not revenue raising, but rather capturing the cost of government services. In your example, the going to the park, that may, those kinds of cases, which I think.
Suppose it goes beyond the cost of running the park. Congress just wants to control admission to the park, regulate admission. Wouldn't that include the imposition of a fee?
So if it doesn't raise revenue, then, and it's not about that, then I think that's fine. If it does.
It raises revenue.
Then I think it's a tougher.
That's the hypothetical. That wouldn't apply?
So I think in that circumstance that it wouldn't be a regulation in context, it wouldn't be permitted. That is, at least in the context of tariffs and trade, we know, Justice Alito.
Okay, well, that gets into your other arguments. We start out with the bare statutory language, and that was what my question was about. Do you think all tariffs are revenue raising? Suppose that instead of imposing these across the board tariffs, suppose that an executive order imposed a tariff on one particular country and provided that this would take effect in 90 days. And suppose that within those 90 days, an agreement is reached with that country so that no tariff is ever collected. Would that be a revenue-raising tariff?
I take it the initial point and on its face, it is revenue raising, that's what it's for. And so I think that would. And look, I don't doubt that there are edge cases. That is what this court's confronted just recently in FCC versus Consumer Research. And you said, look, what is a tax is sometimes very hard. What is revenue raising? This is obviously revenue raising. Their own brief to the court says it's going to raise $4 trillion. And Justice Alito, you in your Consumers Research dissent, or Justice Gorsuch's dissent that you joined, said taxation is special and different. And it is the most powerful thing the government does. And the idea that Congress, when they know exactly how to write tariff and tax statutes, gave this power by implication through the word regulate, I think is very, very hard.
Well, you cite many different statutory provisions that impose tariffs. And you have a point if that's the relevant universe. What if the relevant universe is tariffs that are imposed in emergency situations?
Yes, so I think it cuts the other way. So, as Justice Jackson said, it's when you're in an emergency situation, the statutes actually have to speak with more precision. The public needs to know because emergencies beget emergencies. And I would say the best way of understanding what Congress does in emergencies is to look at their emergency statutes. Not one has ever given the president a taxation power or a tariff power. We've had all sorts of emergencies for 238 years. No president has ever said, oh, the way to deal with that is I need to have a tariff authority. And as Justice Sotomayor said, IEPA gives already a quota power, so you can get what the foreign policy piece of it is through that. I'd also say, Justice Alito, Dames and Moore, which the Chief Justice referred to earlier, I think is really important here because the Solicitor General in that case made a similar argument to what you just heard on the claims provisions. He said it falls within regulate. Regulate is a capacious term. He said, Justice Alito, what you said, this is an emergency situation. And he said you've got to defer to the president on a major issue of national security about this very statute. And what did the court do? It rejected those arguments and said IEPA doesn't cover this.
You say that this is not, this case does not, that these executive orders do not address an unusual and extraordinary threat. I understand that argument. Suppose that the facts were that it was suppose that there was an imminent threat of war. Not a declared war, but an imminent threat of war with a very powerful enemy whose economy was heavily dependent on U.S. trade. Could a president under this provision impose a tariff as a way of trying to stave off that war? Or would you say no, the president lacks that power.
Couldn't do tariff, but could do quota, embargo, all of those things.
Could do all those things, but the president could not impose a tariff.
Because there's
That's
a
one thing he couldn't do.
There's a category shift between a tariff and the other 8 powers in IEPA because it is revenue raising. So it's not a difference in degree or something like that. That's why, I don't doubt tomorrow.
Even if the purpose of this had nothing whatsoever to do with raising 1 penny. The president didn't want to raise 1 penny. The president wanted to deter aggression that would bring the United States into a war. He would say, no, can't do that.
Yeah, just Alito, I think you've said many times the purpose isn't what you look at. You look to actually what the government is doing. And if you disagree, if you think we're, if you
Absolutely,
think
Crystal.
if you ruled for us and the president says, I need this
Change
power,
the law
he can
before
go
you
to
break the
across
law.
the street to Congress tomorrow and get it by a simple majority through reconciliation. But if you vote for them, this power, as Justice Gorsuch said, as Justice Barrett said, is going to be stuck with us forever. The power to jump.
Can I ask you? I just wanted to give you a chance to address kind of the other argument that's been submerged here textually. Again, just bare text for a moment, okay? We've been focused on regulate importation, but actually the statute says the president may, by means of licenses or otherwise, regulate importation. And we've had some discussion today about the fact that maybe the president could simply recharacterize these tariffs as licenses or rejigger the scheme so that they are licenses. We've also heard the suggestion that otherwise, licenses and tariffs are very similar, so otherwise might encompass tariffs there. Thoughts?
Yeah, a few thoughts, Justice Gorsuch. First is, the SG is not even making that argument, and I think they're not making it for a number of reasons. One is that there's a strong presumption against reading statutes this way in the unique tax and duties context. Hartramp is one of those cases which says if there's doubt, you don't read the statute to confer such powers. Second, if you were to do that, it's open-ended. It allows, and this was your hypothetical, it allows under the word license them to tariff the world, and...
It seems like you're putting a major questions thumb or an interpretive lens thumb on the plain text there. Is that fair?
I think you could call it major questions. I just think it's like Justice Barrett said in Nebraska versus Biden, the most natural way of understanding what this statute is about. We're talking about, under the government's reading, a statute that gives the power to the president to junk the entire tariff.
I understand that, but you're not disputing licenses or otherwise means what it says. You're saying we should interpret that narrowly for particular reasons.
So I think I am disputing it as well. I think the licenses, and this is something Justice Sotomayor was saying, don't expand the power. They are not verbs, and so it is limited to the 9 verbs there.
No, I understand that.
And so regulate, I don't think.
Thank you, counsel. Justice Thomas, anything further?
I'd like to just revisit the point that Justice Alito was making with a similar question. If one of our major trading partners, that's, for example, China, held a U.S. citizen hostage, could the president, short of embargoing or setting quotas, say the most effective way to gain leverage is to impose a tariff for the purpose of leveraging his
So we
position
pay
to
a tax.
recover our hostage?
No, Your Honor. So tariffs are different because of revenue raising, and I think it goes to the point I was saying to you in our very first colloquy, which is quotas, embargoes, and stuff are different for a different reason, which is there's a tariff architecture around Title 19, that in tariff would, like in your hypothetical, would supersede. And here the president is seeking the power to set aside all of our trade treaties unilaterally under the word regulate. I just don't think it can bear that weight.
Justice Alito?
You mentioned other tariff provisions.
Yes,
that
God
you think
is
would be
all-seeing
rendered
and knowing, and He is looking.
If we adopted the government's interpretation of IEPA. One that you didn't mention, which is discussed in an amicus brief, is Section 338 of the Tariff Act of 1930. Why doesn't the plain language of that provision, which does speak about duties, provide a basis for all or virtually all of the tariffs that are at issue here?
Yeah, the government's never made that argument, Justice Alito, and I think for very good reason, because it only applies to MFN violations, which are not at issue here. You can only tariff if the president, quote, finds as a fact that a country satisfies two conditions, including that it discriminates against the United States. There are also a host of other reasons why Section 338 may have lapsed, and that's why no president has ever used it. But look,
what is the argument that it's lapsed? It's regrettable.
How can you say what other presidents didn't use?
Therefore, there are limitations on what and the party's ability to answer each other's arguments or arguments that are made by amici. The amicus brief says that it hasn't lapsed. There are articles that say it hasn't lapsed. What is your argument? What is the basis for your argument that it lapsed?
So two things, Justice Alito. Sections 252 and 301 have been understood by many to have superseded Section 338. And second, I don't think you have to get into this issue at all. We're not here saying that the government doesn't have a 338 power. That's something that can be decided by other courts at other times. As these folks come to the court, as the government comes to the court today, they're citing one statute and one statute only, IEPA, and we submit to you it doesn't come even close to authorizing these worldwide tariffs.
Well, what if the president tomorrow were to say, I'm reissuing these executive orders and I'm invoking, in addition to other authorities, Section 338 of the Tariff Act,
So
1930.
I think at that point we'd have that case. I mean, I'm not here to say that 338 does or doesn't do one thing. I'm responding to the government's argument, which is the invocation of IEPA and IEPA alone. But perhaps that point, Justice Alito, may
So
give
then,
comfort.
I mean, I understand party presentation and all of that, and not being a court of first view. But in these circumstances, if that were to happen, and it might be a realistic possibility, you think, well, okay, then the government would continue to try to collect these tariffs, and the plaintiffs here would have to go back to the Court of International Trade or the district court and challenge it again, and it would have to progress through those lower courts and come back to us when? A year from now? 6 months from now? While the tariffs continue to be collected and the amount that's at stake mounts into the billions. I mean, what are we at now? 100 billion? We get up to $1 trillion? That's what you're suggesting?
So, Justice Alito, I think a few things. One is I think it's rich for the government to be making this argument about the refunds undermining us because they opposed the preliminary injunction in this case by saying, oh, don't worry, we'll give the refunds later. And they sought a stay in the federal circuit on exactly that ground, which was you don't need to implement the federal circuit's decision because we'll give the refunds later on. And now they're suggesting...
Well, that wasn't my question, Mr. Gagliardi. The question was whether it would make more sense for us to address that, if that is a possible justification for these tariffs, for us to address that now and get it over with, rather than having this continue for who knows how long while it goes through the procedures in the lower courts.
Justice Alito, I think that is forfeited 9 ways to Sunday. This amicus brief has been filed in every single stage of this case. The government's never embraced that argument. For them to be able to do so now, I think is way, way too late. But I do think if you rule
very
as we're
manipulative.
suggesting you do against the government, they can go and try and seek to use other authorities, whether it's 338, Section 122, etc. Those are the ways prescribed by the Congress. And as Justice Kavanaugh was saying earlier, every other president has used all this suite of other authorities, 201 for steel, for autos and things like that, 301 for countries like China. This president has come along and said something different, and with all due respect, we don't think IEPA allows him to do this junking of the worldwide tariff architecture.
And what was the view, what were the views of President Trump's immediate predecessors on the question of imposing tariffs or allowing free trade? What was their policy view on that question?
There's been a variety of different views about that, but the executive order, my friend said, well, prior presidents had no occasion to use the tariff power, which is belied by the very executive order he's defending here, which says that the trade deficit has been large and persistent every single quarter since 1976. And we've had trade wars. President Reagan initiated, different ones and the use of different authorities, but never once did a president try and seek IEEPA as the basis to rewrite the entire tariff code.
I found it interesting to hear you make the non-delegation argument, Mr. Cattell. I wonder if you ever thought that your legacy as a constitutional advocate would be the man who revived the non-delegation argument.
Heck yes, Justice Alito. I think Justice Gorsuch nailed it on the head when saying that when you're dealing with a statute that is this open-ended.
Okay, I'm gonna move it. I'm gonna move it to, and I'm gonna shift gears for a minute. Bear with me. Yeah, bear with me. I wanna end out on this note. Can y'all please double tap the screen, hit the like button, like, share, subscribe, join the membership.
Business owners impacted by Donald Trump's tariffs. Joining me now, one of those small business owners impacted by Donald Trump's tariffs, Yair Reiner, founder and CEO of Gowanus Kitchen Lab in Brooklyn and inventor of
small business owners.
Which is manufactured.
So let's.
Joining me now, one of those small business owners impacted by Donald Trump's tariffs, Yair Reiner, founder and CEO of. Joining me now, one of those small business owners impacted by Donald Trump's tariffs, Yair Reiner, founder and CEO of Gowanus Kitchen Lab in Brooklyn and inventor of the Frywall Splatter Guard, which is manufactured in China. And you and I, Yair, thanks for coming back. We spoke in April. You said then that tariffs were killing your business. How is it now?
So I would say that it has been a success. If the point was to pick my pocket as a small business owner, the tariffs have basically been a tax that has taken tens of thousands of dollars out of my family's budget that would otherwise go towards paying the mortgage and paying for my kids' education. So it's been a tough year. I would say the tariffs have been a success if the point was to raise prices on my consumers. I would say the tariffs have been a success if the point was to diminish my business. Having to raise my prices has cost me.
See what I'm saying? We pay for it one way or another.
That has taken tens of thousands of dollars out of my family's budget that would otherwise go towards paying the mortgage and paying for my kids' education. So it's been a tough year. I would say the tariffs have been a success if the point was to raise prices on my consumers. I would say the tariffs have been a success if the point was to diminish my business. Having to raise my prices has cost me about 30% of my sales. And it's also really hurt me in terms of trying to develop new products. When we spoke last time, I was in the midst of trying to decide whether to make my new product in Taiwan or in China. I thought, well, Chinese tariffs are bouncing between 50% and 150%. And Taiwan is at 10%. Let me go with Taiwan, especially because they, unlike China, are supposedly a quasi-ally of ours. Mm-hmm. Well, 6 months later, it turns out I've made the wrong decision because Taiwan, our quasi-ally, the tariffs are 20%, and China, for my product, is 10%. Somehow, amid of all this trade war, China looks like a favored nation compared to our allies.
So if you'll stand by, I have the
because he made a deal with him.
Rob Bonta. His state has a separate case against the Trump administration's tariffs. It's good to have you back. I don't know if you had a chance to listen to Yair. He was here in April. He told us it was bad for his business. Now he's talking about the tens of thousands of dollars, the extra money that it's costing his consumers. You were inside the courtroom today. Give us a sense of what you heard that might be useful to small business owners like Yair.
Well, let me first say I'm sad for our businesses that are being victimized by the president's unlawfulness. They deserve better.
Being victimized.
That he's taking unlawful actions, hurting our businesses who are just trying to get by and make a living. It's hurting their workers. It's hurting
I mean,
our businesses that are being victimized by the president's unlawfulness. They deserve better.
unlawfulness.
You heard that might be useful to small business owners like Yair.
Well, let me first say I'm sad for our businesses that are being victimized by the president's unlawfulness. They deserve better. And it makes me angry that he's taking unlawful actions, hurting our businesses who are just trying to get by and make a living. It's hurting their workers. It's hurting consumers, everyday people, families. It's hurting everybody. And it's unlawful. And a lot of signs for hope for our business community and Americans generally who are paying higher prices instead of lower prices based on the discussion inside the courtroom. It was a 2.5-hour oral argument. It surfaced all the key issues, the plain and unambiguous language of the statute at issue, its legislative history, the historical context, and basically tariffs are taxes. Congress has the power to tax. And the statute that the president relies on to impose 10 to 145% tariffs against nearly all of our trade partners never mentions the word tariffs once, and is never used by any president in its nearly 50 years of existence to impose a tariff ever before. So what he's done is not just unprecedented, it's unlawful. And a lot of what I heard from the justices inside the courtroom today, inside the U.S. Supreme Court, suggested that these tariffs might be ultimately found unlawful. But we'll wait to see. I won't predict or estimate.
It's very
What
unlawful.
they might do. We'll wait eagerly for the hearing and for their order, and whatever it is, we'll comply with it. But I think there's a lot of signs for hope for businesses who are suffering.
I think anybody who watches the Supreme Court, it's a fool's game to think you absolutely know what's going to happen after hearing arguments, but you're absolutely right. There did seem to be a couple of conservative justices who were leaning your way, who were leaning Yair's way. I want to ask you about something that Neil Katyal, the plaintiff's attorney, was asked about reimbursement and what that would look like if the tariffs were indeed overturned. Let me play that for you. This is Neil Katyal.
There's a whole specialized body of trade law, and 19 U.S.C. 1514 outlines all these administrative procedures. It's a very complicated thing. There's got to be an administrative protest. There was a harbor management case earlier that this court was involved with in the United States SHU, in which, the refund process took a long time. There were any number of claims and equitable relief.
So a mess.
So it's difficult,
Okay.
Absolutely.
There are two issues here, right? One, how are they going to rule? But let's say that get the ruling, as I said, that you're hoping for. Can this be made right for all the folks who have suffered financially and otherwise as a result of this?
You gotta make it right.
I thought I'd be a good surrogate because I'm just a compassionate person.
The moment that
I think it can, and as Mr. Katyal pointed out, there's a structure and a process for it. It could take some time, it could be messy, but there's a process for it. But the most important issue is the president following the law or not? He's not. And
is he following the law or not? And he is not.
Is the president following the law or not? He's not. And because he's not, the tariffs need to end immediately. I hope the U.S. Supreme Court
Absolutely.
will find it that way. And what happens next is based on existing law and the administrative process that Mr. Katyal.
It's time for an impeachment that will remove him.
On common sense and justice, everyone who has been the victim of an unlawful tariff, who's had to pay more than they should, who's been improperly taxed by the president who's violating the law and the Constitution, should get a reimbursement and should get a refund. And so that process, should the court decide that that's what should happen, and
take it out of his pocket.
That have sued and on behalf of businesses who've been improperly been victimized by tariffs, that process will kick in, and I believe that there is a way for them to get their reimbursement and their refunds.
California Attorney General Rob Bonta, thank you for coming out of the court and having that conversation with us. We appreciate it, which brings me back to you, Yair. Are you optimistic that you might see some kind of reimbursement?
Look, a reimbursement would be great, but that's not really the most important thing for me. The most important thing is to be able to start running my business in a normal way again, where I can decide where to manufacture, understand what my costs are, develop new products with some kind of visibility of what the landscape looks like. That's the part that's been the most difficult to overcome. The other thing is I have some relationships to rebuild with my manufacturing partners in Asia. It has been really difficult over the last 6 months to negotiate and then go back on my word, then renegotiate and go back on my word because the ground keeps on shifting. The partners I work with, I've worked with them for a long time. They know I'm an honorable counterparty. They want to work with me, but our ever-changing tariff policy has made me an unreliable partner. And I think that is work that's going to have to take some time to rebuild.
Yeah, it's not great for them either, right? Their businesses and their employees. But let me ask you about between now and June, because we're not expecting a ruling until then. We were just talking about the holiday season, how important it is to your business and so many other businesses. What happens to your business between now and June? Because we're not expecting a ruling until then. We were just talking off camera about the holiday season, how important it is to your business and so many other businesses. What happens to your business between now and then? You just hope for the best and fight as hard as you can?
I mean, that's it. My prices have gone up this year. They haven't gone up as much as my costs have because I've had to swallow a part of that. That has definitely impacted my sales.
So less profit in addition to paying more tariffs?
Absolutely. And my costs have gone up by about 30% and my prices have gone up by about 7%. That difference is money that I just don't have either as profit or to be able to invest in my business. And it's also taken a whole kind of section of my business away, which is to do flash sales. And to be able to do flash sales and really market things at a significant discount, you have to be able to have the margin to offer that. So that's completely off the table. And that's been a significant part of my business over the last several years.
Okay, y'all, I'll be back later. Bye.